What you know, Alibiers? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Tuesday, March 25th. Hope you guys are having a good day so far. We're going to keep chipping away at these motions in the Bryan Kohberger case. Tomorrow, I'll be doing some case updates and other cases that we're following, but let's jump into Kohberger for now. We're going to start with the defendant's motion in limine regarding alibi. And it says Kohberger filed his notice on July 24th, 2023, stating at the time alleged by the state that he was inside the King Road home. He was driving his car and not in Moscow. Kohberger advised the state he intended to offer testimony through Cy Ray as a partial corroboration that he was driving south and west of Moscow, Idaho in the early morning hours of November 13th, 2022. The expert testimony involves cell site location information. Kohberger further advised the state of his intention to cross-examine any state expert in that field. After that disclosure, the court heard Mr. Kohberger's fourth motion to compel, where, among other things, Mr. Kohberger sought further records related to cell site location information and called Mr. Ray to testify at this hearing, and the state declined to cross-examine. The state provided records necessary to cell site location information in various batches of discovery consisting of call detail records from AT&T, cell tower lists, and drive test data. The state provided its cast draft report and later a final report. However, no analysis has been provided. The state did not produce a timing advance report for Mr. Kohberger's cell phone. I looked this up, and a timing advance report, it corresponds to the length of time a signal takes to reach the base station from a mobile phone. They go on to say to suggest that Mr. Kohberger is hiding a witness that will prejudice the state. That is not the case. Mr. Kohberger has stated exactly how he will partially corroborate where he was. He will use information contained in the discovery supplied by the state, and he will present the testimony of expert witness Cy Ray. And the state did respond to this and said the objection and response to the state's motion offers nothing new or different. In fact, the defendant appears to now acknowledge that he does not have any witnesses, potentially other than himself, to establish where the defendant was at the time of the alleged offense. They cite the defense filing and say, at best, the witness mentioned by the defendant, Cy Ray, can only testify generally to his opinion about where the defendant was during the early morning of November 13th, 2022. Based on the evidence, we know for a fact that cellular analysis cannot show where the defendant was at the time of the alleged offense, as required by the applicable statute and court rule, because the defendant's cell phone was turned off during that time. The court should enter an order prohibiting the defendant from presenting any evidence other than from the defendant himself, whether by direct or cross-examination, in support of any claimed alibi regarding the specific place or places at which the defendant claims to have been at the time of the alleged offense. In a ruling related to this filing, the judge did deny the defense request to have Cy Ray and David Howell testify at the April 9th and 10th hearing unless the court determines that testimony is needed. The judge said the information the defense seeks to convey with these witnesses can be presented by declarations and that counsel may have the witness available by video streaming during the hearing. Moving on to the next filing, which is by the state, and it regards immediate families in the courtroom. They asked for guidance from the court regarding who the court recognizes as immediate family, and also an order allowing those immediate family members of the victims to remain in the courtroom for the entirety of the trial currently scheduled to begin on August 11th of this year, regardless of when they're scheduled to testify. The Idaho Constitution states a crime victim has the following rights: to be present at all criminal justice proceedings, and the statute extends this right equally to the immediate families of homicide victims, described as parents, mother-in-law, father-in-law, husband, wife, sister, brother and sister-in-law, or a son or daughter. They also say the Black's Law Dictionary defines immediate family as a person's parents, spouse, children, and siblings, as well as those of the person's spouse. Now, the state did attach a list of immediate family members who should be allowed to sit in regardless of when they're going to testify. They redacted the names, but for Ethan, they are saying it would be his mother, father, brother, and sister. For Kaylee, it would be the mother, father, sister, brother, and two grandmothers. For Xana, mother, father, and sister. And for Maddie, mother, stepmother, father, stepfather, stepsister, and her grandmother. The defense responded to this motion and says that Mr. Kohberger objects to this request on the basis it's too narrow in scope and the court's guidance should be broadened to address related topics discussed below. First, the individuals identified by the state as family members of the victims include mothers, fathers, a stepmother, a stepfather, brothers, sisters, a stepsister, and grandmothers. The term immediate family is susceptible to varying interpretations. Black's Law Dictionary and relevant definitions in the Idaho Code clearly include parents and siblings as immediate family members. Whether stepfathers, stepmothers, stepsisters, or grandmothers are included within the definition of immediate family is less clear. For the purpose of giving victim impact statements, relatives related by marriage, such as in-laws, are immediate family members. Using the logic set out in Payne, step-siblings of the victim have been recognized as immediate family members. Following this logic, it is likely that step-parents are relatives related by marriage that would be included in the immediate family. In the recent Vallow and Daybell trials held in Ada County, grandparents of the victims remained in the courtroom throughout trial. Statutory definitions, dictionary definitions, case law, and local practice combined would allow all family members identified by the state to be considered part of the immediate family. Thus, Mr. Kohberger stipulates to the individuals listed on Exhibit S1 as being considered immediate family. Second, Mr. Kohberger respectfully requests the court's guidance outline proper courtroom decorum, which discourages spectators from wearing T-shirts. For example, T-shirts with a picture of the victim on them and the words "in memory of," or T-shirts about shooting Mr. Kohberger, or about the passage of Idaho's firing squad legislation, buttons, or other apparel with words, photos, or artwork that can be observed by the jurors, since such conduct poses a coercive threat to the jury's ability to remain impartial. In court proceedings, a family member of Kaylee's wore a T-shirt to court relating to the passage of Idaho's firing squad legislation. They link a news article where they reported that Kaylee's relative wears pro-firing squad shirt at Bryan Kohberger's hearing. From everything I've read, it was Kaylee's father. The T-shirt read "Justice for K," and they just have the letter K, and Idaho House Bill 186, shots fired. This must not be allowed in any future courtroom proceedings, and they cite case law, which says trials must be free from coercive or intimidating atmospheres and the possibility of prejudice if things such as buttons and T-shirts are worn. In Nebraska, the trial court instructed deputies to exclude persons wearing memorial T-shirts and buttons. They go on to say that Kohberger requests the court's guidance to include his family members' presence in the courtroom. His immediate family consists of his parents and two sisters, and they say his Sixth Amendment rights would be violated if his immediate family was excluded. The state responded to that defense filing, saying they are in agreement that immediate families should include step-parents and relatives by marriage, and that Kohberger stipulated to the witnesses the state listed as immediate family. The defendant requests that members of his family be granted the same right as the victims' families. However, the immediate families of homicide victims have constitutional and statutory rights to attend pursuant to the Idaho Constitution. There is no comparable constitutional or statutory provisions affording a defendant's family these same rights. Further, there is no authority to support the argument that the defendant's Sixth Amendment rights would be violated. The defendant has a constitutional and statutory right to a public trial, but that does not extend to the defendant's choosing who sits in the courtroom. In addition, the state may call members of the Kohberger family to testify at trial. They say prior to the start of the trial, they plan to motion the court or the court will on its own accord, generally excluding testifying witnesses from the courtroom so that they cannot hear other witnesses' testimony. His family are not exempt from the Idaho rules of evidence, and they finish by saying the defendant's family is on the state's witness list and should be excluded from the courtroom until they testify. As far as allowing investigators to sit in the courtroom during trial, the defense did stipulate to allow investigators to be present without limiting their ability to testify. In another motion, the defense filed a motion in limine regarding inflammatory evidence, saying they're asking the court to prevent the state from introducing irrelevant and unfairly prejudicial photographs, testimony, and other exhibits to protect his right to a fair trial. And they cite the 5th, 6th, and the 14th Amendments of the U.S. Constitution, as well as Section 1, Article 13 of the Idaho Rules of Evidence. They say evidence may be more prejudicial than probative, and they say the case contains over 68 terabytes of data. That is insane. So I looked it up. How big is 68 terabytes of data? That's over 5 years of video, or 68 million photos, 22.6 million songs, 5.9 years scrolling through TikTok, 26.1 million ebooks, 129 years of music, and 97 years of playing video games. That blew my mind, y'all. But back to the evidence. There's thousands of photographs with many depicting the same content, including depicting the deceased as well as the same location without the deceased. There's many hours of body cam footage depicting the officers moving throughout the house, hundreds of photos of autopsy proceedings, and over 100 officers and investigators have been involved in the case, and hundreds of people have been interviewed. Mr. Kohberger acknowledges the Idaho Supreme Court has held that a photograph cannot be excluded merely on the basis of being gruesome. However, Mr. Kohberger is not making that motion. Rather, he is requesting the state be prevented from introducing inflammatory evidence. Multiple studies have found that mock jurors are more likely to convict when exposed to graphic photos. Mr. Kohberger's right to a fair trial, free from irrelevant, cumulative, and unfairly prejudicial evidence as guaranteed by the Constitution of the state of Idaho and the United States of America, would be violated to allow exhibits depicting gruesome details or the emotional reactions of the police officers at the scene or during their testimony during the trial. So we will see what the judge rules. I'm keeping an eye on the website for any updates. But right now, there are sometimes 10 or more filings put up there a day since the judge did ease up on how much is being sealed in this case. So if anything new pops up, I will likely do a YouTube short before I get to an episode. So if you're not following me on YouTube, go hit subscribe. And if you want notifications of when I post new content, just click that little bell icon. That is it for today. Hope you guys have a good rest of your afternoon, and we will see you soon.